Whoa, hold up. Did you catch that opening? The defendant is already tense, the stakes sky high. Audience, notice how quickly this scene establishes conflict. A young child's mother involved, emotions running wild. This is the kind of moment that sets the tone for courtroom drama.
Whoa, hey, shut up. I ain't said that. Yeah, you no. Hey, look,
sir. Sir. He is arrested.
17-year-old little child, mother.
He is under. There's a motion for a bond reduction in your case. Go ahead. It's your motion.
If you could swear him in, Judge.
Raise your right hand. Lower your hand.
Mr. Johnson, you're currently charged with the offense of murder. Is that correct?
Yes, sir.
It is how much now?
It is $250.
It is $225,000 right now.
And prior to this incident, where were you working?
TDCJ.
And how long did you work there?
Year 2 months, 3 months, roughly.
Where were you born and raised?
Hold on. You were working there. What were you doing there?
Correction officer.
He was a correction officer.
Okay, that's what I thought. Okay.
TDC. And so you've lived all your life in Baltimore.
Yes, sir.
Do you have family involved?
Yes, sir.
And who do you have involved?
Mother, my father, and several relatives.
Do you have brothers and sisters?
Yes, sir.
Okay, and they lived there all your life.
Yes, sir.
You have tried to post a $250,000 bond.
Right. Sir.
This time, you have sufficient assets in order to post the bond. So you've asked your parents or your family to ask around if they have sufficient. If they're requesting, correct? No, sir. And that's in excess of 25.
We're still office.
Do you have any real property or any retirements or anything that you can cash in or sell?
Check this out. The defendant admits to shooting at someone trying to steal his car. But here's the legal kicker. Defending property versus using lethal force is not the same in the eyes of the law. Stick around because the judge is about to break down exactly why.
Getting them funds.
Sir.
In fact, you don't even have a vehicle.
Yes, sir.
Are you asking, so you have no assets at all to post? You asking this court to reduce the bond to a reasonable amount so that you may post it and you abide by all the rules and regulations. What may impose, for instance, it may be staying at the parents' house or definitely within the jurisdiction of this court or this area, and other type of regulations to be able to do whatever this is. And pass it in the street.
Spain, any questions of the defendant?
You never denied being in the shooting, right? Matter of fact, you were shooting at an individual that was stealing your car. Is that correct?
Yes, sir.
And then after the car wrecked, you went back inside your apartment and got a shotgun and came back out while the person was inside the car and shooting, right?
I'm going to have to ask him not to under oath to say anything. There's a probable cause out there.
All right. I'm waiting for it.
Oh.
If she's getting it. Well, I don't have it. It's not in the file.
So you're going to advise him to take the fifth on the rest of this? You're not going to let him testify the rest of this?
Well, we're going to trial.
Huh?
No, we're just talking about the hearing right now.
Yes, sir, just for this.
Do you want to ask any other questions? Or
no, sir. If he's not going to let him answer any more questions on that part.
All right. Let's talk about the rules for setting bail. This is found under Article 17.15 of the Texas Code of Criminal Procedure.
All right, legal nerds, pay attention. Article 17.15 is all about bond considerations for serious offenses. The court has to weigh the nature of the crime, violence involved, and community safety. It's like the judge is juggling a million moving pieces while keeping it fair. And that's exactly what's happening here.
Procedure. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense is an offense involving violence as defined by Article 17.03. The defendant has been indicted with the offense of murder, alleged to have occurred on or about July 30th, 2023. It is alleged shooting the victim with a firearm. And so, this is a first-degree felony, which is a most serious offense, and this felony is also a crime of violence. What these multiple pages involve are not arrest warrant affidavits. These are search warrant affidavits, which, though, include information concerning the alleged offense. All right, essentially, this affidavit for search warrant seems to state that on July 30th, about a year ago, this happened last year, Beaumont police respond to 6550 Phelan Boulevard in Beaumont in reference to a shooting. And a deceased body of Zavan Massie was discovered in the driver's seat of a white 2017 Nissan Pathfinder. That was your vehicle? Yeah. Massie had succumbed to multiple gunshot wounds, according to this affidavit. And the vehicle showed extensive front-end damage, plus multiple bullet impacts along the driver's side of the vehicle. Officers found a trail of 9mm shell casings tracing back to a parking spot in front of a particular apartment at that location. The vehicle was registered to the defendant, who resided there. And according to this affidavit, a witness or witnesses stated that they perceived that someone was attempting to steal the defendant's vehicle. And this is, looks like 10 o'clock in the morning. The defendant ran after the vehicle, yelled at the driver to stop. It did not. And the defendant started shooting at the car with a pistol he had. The car was wrecked. The defendant went back inside the apartment and retrieved a shotgun, approached the car, and began shooting at it with the shotgun. The defendant
Goes inside, grabs a shotgun, and comes back. That's not just an action. It's an aggravating factor that will heavily influence bond and eventual sentencing. Audience, ask yourself, when does defending yourself cross the line into criminal liability?
was interviewed. He declined to answer any questions without an attorney present. However, he volunteered one statement that he stated he was getting ready for work and someone was stealing his vehicle. Okay, so there are the details from the affidavit for a search warrant that was granted by a district judge concerning the facts of this case. Okay, so the nature of the offense and the circumstances under which the offense are committed are to be considered. And again, this offense, which was alleged to be murder in that it alleges by the grand jury that the defendant intentionally and knowingly caused the death of another with the use of a firearm. So it is an offense involving violence, a most serious offense, murder. So that is an aggravated factor in determining bond. Then the future safety of a victim of the alleged offense in law enforcement community shall be considered. Well, I don't think that's an issue here because the victim in this case, or the complainant, is deceased. Now, I don't, you've presented
This is the key moment. The car is disabled, yet the defendant continues with lethal force. In legal terms, that's not self-defense anymore. That's considered revenge. Judges have to separate initial intent from subsequent actions, and this is exactly where bond decisions hinge. And there it is. The judge makes it clear, bond stays. Notice how they balance acknowledging human instincts to protect property with the absolute limits of the law. For viewers, this is courtroom clarity in action. Intent matters, but so do the rules.